month-long break, the prosecution resumed its cross-examination of former church fund manager Chew Eng Han this week. On Tuesday, the trial crossed its 100th day mark. DPP Christopher Ong continued to build the prosecution's case that the bond transactions were sham, focusing on two key points. Firstly, the prosecution holds that the defendants never believed the Extron bonds entered into in 2007 could be redeemed, hence the bonds were sham. Tan Ee Peng's lawyer, senior counsel N. Srinivasan, asked the prosecution if it included refinancing in its position, to which the DPP Christopher Ong reiterated the belief that the 6 defendants entered into the bond transactions knowing they could not be redeemed and so kept the plan going to continue funding the crossover. Srinivasan then asked if it was the prosecution's case that short-term borrowing or refinancing for long-term liability was an offence. The prosecution's second key point was the Furna bonds were sham because there had never been any intention for Furna and Wahyu Hanafi to repay the bonds. The bond proceeds were never meant for Furna's use but were intended to finance the crossover project. To this, Chew maintained that Furna had legal obligations to make good on the repayment. He also pointed out that in 2010, Wahyu Hanafi had personally taken up bank loans to redeem the bonds in full. When questioned at length by the DPP on whether the real motivation behind the ARLA was for the redemption of bonds, Chew told the court that there were two intentions for the ARLA: to give Extron the mandate for property search and to redeem the bonds. The prosecution pointed out that the defendants had given the auditors an inaccurate picture of control over Extron in order to avoid consolidation. He also attempted to show that Raja and Tan lawyer Christina Ng had not received complete information about the bonds, the ARLA and the secret letter when she was tasked to draft the legal documents. Chew repeatedly denied this, insisting that the auditors had knowledge and that Ng knew and understood the purpose behind the transactions. The prosecution challenged Chew about the Special Opportunities Fund, alleging that the retrospective manner in which the interest rate of the SOF was set showed that the SOF investments were not genuine investments and that these were not commercially motivated transactions. Chew responded that an investment is defined by the expected returns and not the process or structure by which it is carried out. He also added that he had never claimed the SOF investments were commercially motivated, but were done because he understood Auditor Sim Guan Seng had wanted the Furna bonds off the books. The prosecution continued to press Chew on the knowledge of the church board, auditors and lawyers had about the bond transaction. The crossover project needed more funding, and then manager partner of audit firm Baker Tilly, Fung Dao Ching, told the CHC team that disclosure of CHC's transactions with Extron would become necessary if the church bought more bonds from Extron. Chew then proposed for CHC to buy bonds from Furna instead. While Chew agreed that the underlying motivation for this was to avoid the disclosure of the use of the church's building funds to finance the crossover project, he disagreed with the prosecution that it was done to prevent the auditor's scrutiny into the alleged sham nature of the bond investments. He said that Auditor Fung had lied on the stand when he told the court he did not know anything about CHC's Furna bonds. Chew also disagreed with the prosecution's claim that he conspired with the other defendants to actively conceal the true nature of the bond investments from the church's board members. He explained that, in fact, a board resolution had been drafted by lawyer Christina Ng, documenting the underlying purpose of the bonds. The auditors, lawyers and the CHC board had understood the discretion about the funding of the crossover project was necessary for its success. When the prosecution made a sweeping statement in court yesterday that it was uncharacteristic of co-defendants Kong Hee and Tan Ee Peng to tell the board things, Chew told the court that he knew Tan did not hide things from the board, and neither was Tan afraid the board would not show support because it was very supportive of the crossover. In Chew's re-examination, he addressed the prosecution's put that mixed motive investments were an afterthought to conceal the alleged sham bonds and round-tripping transactions. Chew listed examples of other entities set up by the church that also had mixed motives, mainly to reach out to the unsaved, but also to benefit the community at large. Even the search for a property had mixed motives because it was not solely for commercial purpose, but also with the intention to contain the growth of the congregation. Chiu told the court that the crossover project is about bringing the gospel outside the four walls of the church and ultimately to China. This has always been the direction and understanding of the CHC board and the crossover team, including the 6 defendants. Re-examination of Chiu will be completed on Monday next week, and Tani Peng will take the stand. For more information, please log on to citynews.sg. I'm Andrea Lim for City News Singapore.